not yet brought an application for bail. His legal representative has indicated that he has not yet received any instructions to proceed with the application. Accused number 3 is a company called Rising Estates Pty Ltd, as represented by accused number 1. Accused number 1 and 2 appeared for the first time in court on the 17th of October 2020. The state indicated that their investigation in terms of Section 50, subsection 60 of Act 51 of 1977, insofar as accused number 1 and 2 are concerned, is finalized. Therefore, a date of the 30th of October 2020 for a formal bail application was arranged with their then legal representative, Advocate Bronnie, who stood in for Mr. De Meyer. Accused number 4, number 5, and 6 were subsequently arrested on the 20th of October 2020 and made their first appearance in court on the 21st of October 2020. Accused number 4, 5, and 6 first appearance. On their first appearance, the state brought an application for a remand in accordance with the provisions of Section 50, subsection 60 of Act 51 of 1977. In support of its application, the state presented Exhibit A, which is an affidavit attested to by G.N. Marie, who is part of the investigating team. The application for a Section 50, subsection 60 of Act 51 of 1977 was vehemently opposed by the defense. In return, the defense submitted that they are ready to proceed with an application for bail. In opposing the state's application for a remand in terms of Section 50, subsection 60 of Act 51 of 1977, Exhibit B, which is a court judgment handed down on the 21st of October 2020 in the Gauteng Division in Pretoria. Exhibit C, which is accused number 4's affidavit. Exhibit D, which is accused number 5's affidavit, as well as Exhibit C. Exhibit E, which is accused number 6's affidavit, all of which were submitted to pursue the court not to grant the state a remand and for a formal bail application to proceed. Due to the expired court hours, the matter was remanded until the 23rd of October 2020 for the parties to finalize their arguments in respect of the state's application for a remand. On the 23rd of October 2020, accused number 4, 5, and 6 were brought before court. The parties finalized their submissions. The court made a finding that there is no reason why the formal bail application should not commence and that the state had time to finalize the investigation in terms of Section 50, subsection 60 of Act 51 of 1977 prior to the arrest of the accused. This was confirmed when accused number 1 and 2 appeared before court. Furthermore, the state indicated that the charges fall within the ambit of Schedule 5 of Act 51 of 1977 as amended, which effectively implied that the defense bears honors and has to start. It also became clear that the court hours were going to expire shortly. This effectively granted the state an advantage of the weekend within which to finalize whatever investigation that they still required. The state's application for a remand in terms of Section 50, subsection 60 of Act 51 of 1977 was therefore dismissed. The defense then proceeded with their application for bail in respect of accused number 2, number 4, number 5, and 6. All 4 applicants, that is accused number 2, 4, 5, and 6, proceeded by way of affidavits as well as documentary evidence. They thereafter closed their cases. No oral evidence was laid. The state also responded by way of an affidavit, Exhibit M, which is an affidavit attested to by G.N. Marie, who is part of the investigating team, together with documentary evidence. No oral evidence was laid. Accused number 2, 4, 5, and 6's application for bail fall within Schedule 5 of Act 51 of 1977 as amended due to the fact that they are facing charges of fraud, theft, and money laundering to the tune of 106,064,813 rand. Accused number 4 and 5 also have a pending case wherein they have been arraigned on several charges, including fraud, forgery, money laundering, contravention of Item 25 of Schedule 1 of the Prevention of Organized Crime Act number 121 of 1998, and contravention of Regulation number 6 subsection 1 and 6 subsection 6 of the Exchange Control Regulations. They are due to appear in court for plea and trial from the 31st of May 2021 to the 18th of June 2021. In terms of Section 35 of Act 108 of 1996, that is the Constitution of the Republic of South Africa, deals with the rights of arrested, detained, and accused persons. Section 35, subsection 1F provides that everyone who is arrested for allegedly committing an offense has the right to be released from detention if the interests of justice permit, subject to reasonable conditions. However, the right as conferred by the provisions of Section 35, subsection 1 of the Constitution are not absolute. They are subject to the provisions of Section 36 of Act 108 of 1996, which is the limitation clause of the Constitution. Offences which fall within the ambit of Schedule 5 of Act 51 of 1977 as amended are governed by the provisions of Section 60, subsection 11B of Act 51 of 1977, which provides that where an accused is charged with an offense as referred to in Schedule 5, the court shall order that the accused be detained in custody until he is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that the interests of justice permit his release. Position regarding accused number 2, it has been argued on behalf of accused number 2 that she is not the so-called main accused in this case. Seemingly, her detention is by virtue of her marriage to accused number 1. It has also been said that her further detention is not justified. She is a South African citizen. Her entire life is in South Africa. She is a mother to 2 minor children, one of whom still breastfeeds. She has resigned as a director from accused number 3 in 2017 and has handed her passport to the state. It has been further argued that further detention is not necessary and that there is no foundation of facts for her to be detained, as she bears no knowledge of the charges. The defense argued further that an allegation by the state that accused number 2 will evade her trial and skip the country is a mere speculation which is not supported by any facts. According to the state, bail is opposed in respect of all accused, including accused number 2. Amongst other reasons, the state has raised concerns that the accused are a flight risk, that they will intimidate witnesses, and that their addresses are questionable, in that should they be released, the state will not know exactly where to find them. The defense, on the other hand, has argued that the state has not furnished the court with any solid evidence in terms of Section 60, subsection 4, A to E of Act 51 of 1977 in respect of accused number 2. It has also been placed on record that accused number 2 suffers from anemia and requires medical attention, and that should bail be granted, she can only afford 20,000 rands as she is not employed. In respect of accused number 2, I find the following. Indeed, accused number 2 is married to accused number 1. She's a South African citizen, she has 2 minor children, and she has already handed to the state her passport. Accused number 2 has no previous convictions or any pending cases. The state's concern that she's a flight risk is only a concern that is not substantiated by any solid evidence. It is not in dispute that accused number 2 resigned from Rising Estates in 2017. Rising Estates is accused number 3 in this matter, as represented by accused number 1. Position relating to accused number 4 and 5. Accused number 4 and 5 are Malawian citizens. They presently hold the status of permanent residency in South Africa. They have a pending case as mentioned above in paragraph number 18. In the face of a concern to self-incrimination and to also be able to exercise their right to remain silent in the pending case, accused number 4 approached the North Gauteng Division by way of an application seeking an order that the respondents, namely the Minister of Home Affairs, the Acting Director of Home Affairs, and the Department of Home Affairs Senior Administration Officer, be interdicted from withdrawing his and his family's permanent residence permits, and that the 30-day period within which he was afforded to make representation be put in abeyance until such time when the pending criminal trial in the Gauteng Division, Pretoria, is finalized, alternatively until he and his wife have pleaded and the evidence has been laid in the Department of Home Affairs related charges. Judgment in the matter referred to in paragraph 35 supra was handed down on the 21st of October 2020. The court held that the notice issued by the Department of Home Affairs dated the 2nd of August 2020 is suspended until when the applicant, that is accused number 4, and his wife, that is accused number 5 in this case, have pleaded to the charges, and once they have pleaded, they be afforded a period of 30 days from the date of plea within which to make any formal representations as envisaged in the notice dated the 2nd of August 2020. The effect of this judgment, as referred to above, is that accused number 4 and 5 status of permanent residence in the Republic of South Africa remains unchanged. According to the defense, accused number 4 and 5 are leaders in a church called Enlightened Christian Gathering and are prominent members of their community. It has been argued that they are not a flight risk due to one of the reasons being their large role in the community and a large number of followers. It has also been argued that it is not possible for accused number 4 and 5 to can hide as they are well known. The state has argued that accused number 4 and 5 are a flight risk and that there is a possibility that if released, they will interfere or intimidate witnesses. With regards to accused number 6, it has been argued that accused number 6 is married and has no children. The defense further argued that accused number 6 is not a flight risk as she has strong family ties within the Republic of South Africa, which includes her mother, who she is financially maintaining. Accused number 6 has no pending cases or any previous convictions. She also has proof that she has 2 immovable properties that she jointly owns with her husband. The state, on the other hand, argued that accused number 6's address is questionable and that she is a flight risk. The state also argued that all applicants in this matter, including accused number 4 and 5, are a flight risk due to the fact that they have multiple passports, their residential addresses are unclear, and that there is an incentive for them to flee due to the seriousness of the allegations, as well as possible heavy sentences that might be imposed should they be convicted. In State versus Fermas, 1996, Volume 1, SACR 528T, Judge van Dekhorst referred to Section 60, subsection 4B of Act 51 of 1977 as the prime consideration whether the accused will stand his trial. He held that Section 60, subsection 4B must be read with Section 60, subsection 6, taking the following grounds into account: the emotional, family, community, or occupational ties of the accused to the place at which he or she is to be tried, the assets held by the accused where such assets are situated, the names and travel documents held by the accused which may enable him or her to leave the country, the extent to which the accused may afford to forfeit his bail, the question of whether he or his extradition could readily be affected, the nature of the gravity of the charge, the strength of the case against the accused person, the nature and gravity of the punishment, the binding effects of bail condition, as well as any other factor that the court deems fit to take into account. Bail is never to be viewed as a punishment or incentive. It is only a means to secure the accused's attendance of the criminal proceedings. If bail is granted to an accused person, that is never to be interpreted as an indication that the accused person is likely to be acquitted or he or she is likely to be convicted. If bail is denied as well, that should never be interpreted as an indication that the accused person is going to be convicted or he's going to be acquitted. As I've said, bail is only a means of securing an attendance of the accused person of the rest of the criminal proceedings. At the bail proceedings, it has to be borne in mind that a presumption of innocence still applies and that the court has to be satisfied on a balance of probabilities that the accused, if released, will attend the rest of the criminal proceedings, will not interfere with the investigation or with the witnesses. This was also pointed out in S versus Firmas 1996, volume 1, SACR 528T. In S versus Fakwir, it is a 2014 decision, JDR 1351 GP. The court held that the magistrate is concerned that the accused, who is a foreigner, would not stand trial, has to be based on objective facts that there was a likelihood that she would flee, but simply on the basis that she was a foreigner. In this matter, the state has made submissions that accused number 4 and 5 have disposed of their properties, that is, their vehicles. However, no evidence was placed before court to substantiate same. A certain website was referred to. The court therefore makes the following findings. In respect of accused number 2, she is a housewife with 2 minor children. She has no previous convictions or pending cases. Therefore, bail is fixed in the amount of 20,000 rands, subject to conditions that will be announced shortly. In respect of accused number 4 and 5, they currently hold the status of permanent residence, although that status is still a concern to the state and under investigation, but the fact currently remains that they are permanent residents and that status still stands at the present moment. Should accused number 4 and 5's permanent residency status be revoked whilst this case is still pending in court, the state will then exercise its rights in respect of in terms of Section 68 of Act 51 of 1977. Accused number 4 and 5 are known, and the likelihood of them absconding is very minimal. Bail in respect of accused number 4 and 5 is fixed in the amount of 200,000 rands for each of them, with conditions to be announced shortly. Bail in respect of accused number 6 is fixed in the amount of 100,000 rands, with conditions to be announced shortly. Accused number 2, number 4, number 5 and 6, please rise so that you can listen to the bail conditions. Please listen properly and attentively. Accused number 2 is to report to her nearest SAPS office every Monday and Friday between 6 in the morning and 6 in the evening until when this case is finalized. Accused number 4 and number 5 are to report to their nearest SAPS office every Monday and Friday between 6 in the morning and 6 in the evening until when this case is finalized. Accused number 6 is to report to her nearest SAPS office every Monday and Friday between 6 in the morning and 6 in the evening until when this case is finalized. The fourth condition, accused number 2, 4, 5, and 6 are completely barred from traveling outside of the borders of the Republic of South Africa until when this case is finalized. Accused number 4 and 5 are barred from traveling anywhere else in the Republic of South Africa. They can only travel within the Gauteng and Northwest provinces borders until when this case is finalized. The travel documents of accused number 2, 4, 5, and 6 that have been handed to the investigating officer are to remain in the investigating officer's possession until this case is finalized. The accused are also barred from applying for any travel documents whilst this case is still pending in court. Accused number 4 and 5 are to hand over an original title deed of a property that is jointly owned by them. The details of the property, as mentioned in Exhibit C and D, are 1585 Midstream Estate House, situated at Midstream Estate, Centurion, with a purchase price of 5.5 million rands, as a guarantee that they will attend the rest of the criminal proceedings, and that should either of them abscond, this property shall be deemed forfeited to the state. The original title deed shall be handed to the National Prosecuting Authority's Assets Forfeiture Unit for safekeeping on or before the 5th of November 2020 at 6 in the afternoon at the NPA's VGM building, Silverton, Pretoria, and will be kept safely by the state until when this case is finalized. Accused number 4 and 5 are barred from disposing of the property as mentioned above or obtaining any new title deed for the said property until when this case is finalized. Accused number 2, number 4, and number 2, 4, 5, and 6 are not to intimidate or threaten state witnesses in this case directly or indirectly. Accused number 4 and number 5, please listen attentively. In your preachings or any platform to your congregants as well as your followers, you are barred from making any threats towards the state witnesses, the members of the prosecuting team, and the members of the investigating team. Accused number 2, 4, 5, and 2, 4, 5, and 6 must bear in mind that if any of these bail conditions as mentioned above are adhered to, if they are not adhered to, the state is at liberty to bring proceedings before court in terms of Section 68 of Act 51 of 1977, that their bail be cancelled and their money be forfeited to the state. Do you all understand? What do you want to do with the matter, Steve? What do you want to do with the matter?
Head of the state with request for further remand. May I suggest a date? I didn't look at the date.
It seems like Advocate Mokotwane wants to address the court, yes? Pardon?
Worship, we are ready to proceed with bail application. If maybe the worship is amenable to that. And if not today, worship, maybe on Friday. Worship.
Are you available for case number 1's bail application on Friday?
I am here, sir.
Mr. Matoko, will you be be available on Friday.
Let's copy on Friday.
Accused number one's formal bail application. Obviously, your clients have to be in attendance.
Yes, I can be available on Friday. So
Pardon?
I can be available on Friday.
Thank you. And what about you, sir?
It's a copy, Your Worship. I can be available on Friday as well.
Your case is remanded until this coming Friday, 6 November 2020, in court number 16. It is for accused number one's formal bail application. Accused number one, please rise. You'll be in custody until Friday when the court will listen to your formal bail application. Accused number two, as I've said, your bail is 20,000 rands. If you pay it, you are going to be released. You must be back 6 November 2020, court number 16 at 8:30 in the morning. If you pay bail and you fail to appear in court, the warrant is going to be authorized for your arrest. You'll be arrested, you'll be kept in custody, and your bail money will be forfeited to the state. You must also adhere to the bail conditions. Do you understand? Accused number 4 and 5, as I've said, your bail is 200,000 rands each. If you pay it, you are going to be released. You must be back 6 November 2020, court number 16 at 8:30 in the morning. If you fail to appear, the warrant will be issued, you'll be arrested, you'll be kept in custody, your bail money will be forfeited to the state. Accused number 6, your bail is 100,000 rands. If you pay it, you'll be released. You must be back 6 November, 8:30 in the morning. As I've said, if either one of you does not adhere to bail conditions, you are going to be rearrested, you'll be kept in custody, your bail money will be forfeited to the state. Once the court has held any inquiry and it turns out in that inquiry you are in the wrong. So please make sure that you adhere to the bail conditions. The bail conditions are in writing. In case you didn't understand any of them, your legal representative will guide you. I will attach them to the chat sheet so that you can refresh. Mr. Matoko, this original title deed, when is it going to be handed to the National Prosecuting Authority? I've given you until 5 November, 4 o'clock in the afternoon, but I want to have a commitment from you. When are you going to have it handed in?
As the court pleases, Your Worship. Your Worship, I'm going to endeavor, but I'd ask the court's indulgence to hand it in on the 6th.
No. I've made a ruling, I've made an order that it has to be handed before 5 November, 4 o'clock in the afternoon. If I don't have it by then I'm going to have to cancel your client's bail.
No, Your Worship. I'll endeavor to have it handed into the prosecuting minister.
All right.
As the court pleases.
As a court pleases, Your Worship.
Can we adjourn?
That is the role so far as I know. Thank you.
All right, yes.